All right, so I'd like to do a little bit of an introduction, and then I'm going to turn it over to our speakers. So if you don't know, Sunshine Week is the national celebration of freedom of information and open government. So we have two speakers today. We have Becky Richards, and we have Alan Gernhardt. And Becky Richards is the Director of Civil Liberties, Privacy, and Transparency at the National Security Agency. She is the lead person at the NSA responsible for how the NSA is held accountable for upholding America's law while providing critical foreign intelligence information to keep Americans safe. Just a little more about Ms. Richards. Ms. Richards received the President's Meritorious Rank Award in 2017 for her work at the NSA on civil liberties, privacy, and transparency. And in 2008, she was honored with the Secretary of DHS Silver Medal for Leadership and Privacy. Alan Gernhardt is the Executive Director of the Virginia Freedom of Information Advisory Council, which we have already discussed is a mouthful of a title, but
and only half of it.
and only half of it, okay. Wow. He is responsible for Virginians' access to public records under the Virginia Freedom of Information Act. The Virginia Freedom of Information Advisory Council answers questions from private citizens, state and local public officials, and the media about access to public records and meetings. And he is also a Richmond Law alum. So please welcome Becky Richards and Alan Gernhardt.
So who do you want to go first?
Alan, why don't you go first?
All right.
Do you like to walk around? I can offer you.
Oh,
this.
you'll hear me.
Yeah. No, I'd rather.
All
This
right,
room is
I'm
so
there.
cavernous.
That's true.
So here you go.
I remember doing good court in this room.
Yeah.
So I graduated from here 20 years ago. So, yeah. That's sick.
Thanks.
Good?
And she can hear you better too.
All
Yeah,
right.
Thank you.
Everybody hear me? All right. In the back, y'all can hear me too. Good. So, I'm Alan Gernhardt. I am a Richmond Law alum, 02. I am now, let's see, the full title, Executive Director of the Virginia Freedom of Information Advisory Council and Senior Attorney with the Division of Legislative Services. So, call me Alan. All right, don't worry about the title. We're going to spend a little bit of time starting off. We're just going to tell you a little bit about what we do. So, the FOIA Council, Freedom of Information Advisory Council. Before I even get to that, let me ask you, why do we have FOIA? Oh, and I call on you. Go for it. Hold the government accountable, that's definitely one reason. Yeah. What kind of government do we have? Think grade school. What kind of government is this?
Representative government?
Representative? Anything else?
Free, democratic?
Free, democratic? Yeah. Is it a democracy?
Yeah.
Really?
Depends how you define
It's a democratic republic, isn't
Yeah.
it? Is it constitutional? It's a constitutional democratic republic, representative of the people. How did we get here? What's one of the very first things we did in writing? We declared. Who wrote that? Who wrote the Declaration? Let me ask you. I'm getting there, trust me. Who wrote it? TJ, yeah, Thomas Jefferson. This is Virginia, everybody knows that, right? Okay. So there's a line in there that I really like. Government by consent of the governed. Think about that. At the time, they're coming just past divine right of kings, where the king said, I rule because God said so. And we say, no, you don't. You rule by our consent. That was a pretty radical idea, right? Now I want you to think about, anybody ever, your law students, anybody want to do med mal? Nobody? Okay, cool. Nobody wants to go after the doctors. Has anybody gone to the doctor? Yeah? Okay. Doctor ever want to give you a drug, give you some medicine, or do a procedure, run some tests? What's he got to get from you first? Consent. All right, law students, what kind of consent? Informed consent, right, because if you go into the doctor's office and you're wasted drunk, and you say, yeah, cut off my leg. Does that count? Is that good consent? No. If you were the lawyer for that person, would you be going, all right? Yeah, no. So it's got to be informed consent. Apply that to government. We have government by consent of the people. Still has to be informed consent, right? We can't really give consent to our government if we don't know what our government's doing, right? So this is how we're implementing that concept. Another thing I like to point out to people, who here is government? I'm a state employee. Who else is government? Anybody? What would Abe Lincoln say about that? We're a government of the, by the, for the, right? Apply that concept. Anybody ever volunteer to be on a school board committee? Or maybe someday you will. If you have kids, you might. Anybody ever run for office or plan to? Lawyer become a politician? What a crazy concept, right? Yeah. We also, we participate. Some of you might get government jobs like I do. Some might run for office. Some may just go to the polls and vote. I hope you all do, right? But we are participatory government as well. Again, for that participation to be meaningful, it's got to be informed, okay? So why do we have FOIA? It's because of our form of government, so we can give consent to government, so we know what government's doing. My old boss said she was at a conference once and speaking with one of our Canadian counterparts. And he said, well, FOIA is simple. It's just what's government got cooking. That's what it's all about. It's finding out what we got cooking. Now, that said, are there things we're not going to tell the people in general? Sure, of course there are. This is one of the differences, and we'll talk a little more, I think, in a bit about the differences between federal and state. Federal FOIA for records has, 9 exemptions, roughly? Yeah, and they're usually fairly broadly written. One of my favorite examples would be things like national security matters. Well, what does that cover? A lot of stuff, right? Unwarranted invasion of personal privacy. A lot of stuff under that, right? Virginia FOIA, we have over 150 records exemptions. We have over 50 meetings exemptions. So we have over 200 exemptions in FOIA itself, plus you can find more stuff outside of FOIA. Big difference is most of our stuff is very specific. This one's actually gone, but it was a good example. We had an exemption specifically for the subscriber list to Virginia Wildlife Magazine, published by what's now DWR, used to be Game and Inland Fisheries. Just the subscriber list. We have an exemption for Apple Board information about the price of apples. And it's only by the Apple Board. So we have a lot of these very specific ones. So it's a difference in concept and approach of we put a whole lot of little pinholes in our general rule of if it's public information, it's got to be given to the public on request. That's our basic policy. We do have a really interesting policy statement. FOIA is one of the few laws with a policy statement. Most of them don't have it in the beginning, but FOIA does. And it starts off talking about the General Assembly enacts FOIA in order to ensure the people ready access to records and meetings of the government. It says that nothing we do in government is supposed to be conducted in an atmosphere of secrecy. All records and all meetings, by default, are to be open to the public unless there is a specific exemption. If there is an exemption, you can withhold things or close a meeting, but all exemptions have to be construed narrowly. So that's another difference. We actually have our legal construction rules in the policy statement. Everything else in FOIA is to be construed liberally in favor of openness. So we kind of have a balance there. We talk about a balance between government's need to function versus the people's right to know, and we tilted in favor of the right to know from the very start. So FOIA is set up that way. A few things about the FOIA Council. In the mid-late 90s, the press went around and did a survey. They asked for a bunch of public records from a whole lot of different public bodies. I understand it was a nationwide survey. It's actually before I went to law school. But they did this survey and asked, stuff that should have been open wherever they went. And they saw what kind of return they got. And my understanding is Virginia got, I'm trying to remember, I think it was something like, they said a 16% response rate, where it should have been 100, and they got like a 16 or so. And somebody else got even lower, it was New Jersey, I understand. But people said, Virginia FOIA was enacted back in 1968. It had been around for about 30 years at the time. And so the General Assembly saw these results and said, what's going on that people can't comply with the law that's been in place for 30 years? They did a 2-year study. They revamped FOIA, did a whole bunch of amendments, changed the law itself in some ways. A lot of it was just restructuring it, trying to make it clearer. But they also created the FOIA Council. The council has been in existence since 2000, and we are an advisory body in the legislative branch. So our primary role is education. We do presentations like this. I teach CLEs. I teach cops a lot, as well as lawyers, just generally folks in government. In the last few years, they've added requirements in the law that local elected officials, members and directors of EDAs and IDAs, as well as FOIA officers, all get FOIA training every 2 years. So FOIA training has become a really large component of what I do. The other main things I do is I answer a lot of email and phone calls about, hey, do I have to release this record? Or hey, I asked for this and they didn't give it to me. Don't they have to give it to me? And just talking to people. I talk to government folks, I talk to citizens, I talk to media all the time. We publish advisory opinions, we publish educational guides, we have a ton of resources up on our website. But the day-to-day, I mean, we are educational advisory. Sometimes people will call me up and say, I want to file a complaint. Well, you do that in court. I don't handle the complaints, I don't enforce FOIA. I'm not a FOIA cop or a judge, jury, executioner kind of thing. I'm just here to try to help people understand what's going on. I will ask just real quick, any questions about what I do as far as FOIA? Oh, and I should say I've been doing this since 2004, so I'm in my 18th year, which scares me.
So we'll have some time for questions at the end. But thank you, Alan. Let me turn it over now to Becky. Becky, can you hear us?
I can. Can you hear me?
Yes, we can.
Great.
Thank you so
Well,
much for
thank
being
you.
here.
Absolutely, and thanks for letting me, being into you from within NSA. Always happy. I was just at a Sunshine Week event earlier in the day that was being put on by the Department of Defense, and so this is something that is celebrated across. So it's always an opportunity to think about how can we be more transparent, how can we ensure that the people have the information that they need. So I've been at NSA just over 8 years, and I have a mouthful of a title, maybe not quite as much as Alan's was, but as the Civil Liberties, Privacy, and Transparency Officer. My father-in-law would sometimes say that I had an oxymoronic name because NSA means secrecy, and I'm talking about civil liberties, privacy, and transparency. But instead, what I like to say is that we have to do both of these because we are a democratic society. We are a government by the people, for the people, of the people. And we need to really know, what does it mean to have national security, and how do we do that in a transparent way? So let me just start with, what does NSA do? NSA has 2 key missions. We are a signals intelligence agency, which means that we are collecting foreign intelligence about foreigners outside the United States. And we're trying to give our policymakers that information advantage to understand who's going to do what next and how they're going to protect our national security. You're seeing a lot of that playing out today as we see what's going on in Europe. And so there's a real need for that. We also have a cybersecurity mission, which means that we are here protecting the information networks of the Department of Defense, as well as other contractors who may be assisting the Department of Defense. And so we are both looking at what information we can glean from others and then ensuring that we are protecting our own set of secrets from there. My job as the Civil Liberties, Privacy, and Transparency Officer is to ensure that we are building civil liberties and privacy protections into the activities that we do at the national security agencies so that we are protecting your freedoms, and that we are as transparent as possible while maintaining the necessary sources and methods associated with the activities. So let's just take a step back. Sometimes it's helpful to look at definitions, and my title has a bunch of things that can sometimes feel a little fuzzy. So what are civil liberties? You're all law students. You should probably have a sense of what that is. But generally, if we think about what's in the Merriam-Webster dictionary, it's freedom from arbitrary government interference, as with the right to free speech and as guaranteed by the Bill of Rights. So it's that arbitrary aspect of what it means to protect civil liberties. Privacy, another one that can sometimes feel a little fuzzy. Basically, we like to think of it as freedom from unauthorized intrusion. So it's not a whole right. It's not you are always private. And in fact, as a society, there are trade-offs that we're making in that space. And then transparency. And my favorite definition, which is the quality that makes something easy to understand. which often is very difficult because there are a lot of complexity associated with how any organization does its business. And so trying to make that clear and understandable can be tricky. Now it's Sunshine Week, so let's talk about transparency for a quick minute and think about that. When I started at the National Security Agency in 2014, it was shortly after the Snowden leaks that summer. And there were a lot of concerns because people felt like they didn't understand what the National Security Agency was doing, how they were doing it, and if there were any privacy protections in place. And I was already working in privacy at the Department of Homeland Security and said, oh, I'm not sure that looks like a really hard job. I don't know if I want to take that. Well, I ended up going through and getting hired. And what I realized was that NSA, which is often known as no such agency, and didn't have a sign up here in Maryland to say, get off here until the 90s. Just think about that. There was not a sign that said, get off here's NSA until the 90s. And really is no such, it was really seen as no such agency. Had extraordinary civil liberties and privacy protections and no actual ability to talk about it. They really hadn't been in that space. They had been born largely out of secrecy, and they had really taken that seriously and had only slowly been coming forward in that space. So over the last 8 years, we have been really working to both ensure that we are giving as much information and as much context as is possible while continuing to protect the secrets that we really need to keep. You know, it doesn't help if we tell everybody here, and that includes all of our adversaries, how we are able to get certain type of information, because our adversaries are reading the same information we are, and we have seen that in practice. And so we have to be thoughtful about how we give the information out, but we also know that we have a real need to lean forward in that space. And it's something that we think about all day, every day, in terms of what is the type of information that we can give out? How can we explain that information in a way that is understandable to anybody from our middle schoolers all the way to our subject matter experts who are in the civil society, whether it's ACLU, EFF, the Brennan Center, who really deeply have thought through and are thinking about things like the Foreign Intelligence Surveillance Act. So that's a little bit of sort of a broad wash of the types of things that we're looking at. My day in and day out is sometimes my kids like to say I'm a professional meeting goer because I'm learning more about what the agency is doing than talking about what is it that we can say publicly, how can we say that, what are the different ways. Just this morning I was having that conversation to say who needs to know this information. Our overseers, so Congress, the Privacy and Civil Liberties Oversight Board, the Department of Defense, the Department of Justice, the Foreign Intelligence Surveillance Court, and the public. How are we going to present that information? What is the type of information that would be useful and understandable? And we've learned a lot of lessons over the years, particularly in the last 8 years, as to what is more successful and what maybe are places for us to continue to improve. This is a space where there's constantly going to be this push and pull. And what it means is that we have to constantly see how we can do better. How can we give more information that has more context and is more understandable? One of our early lessons was in 2014 and 2013. We saw that we put out a lot of materials that were highly redacted and difficult to understand. And we put them out and we were very proud. Here we go, here's all our materials. Look at that, we've been proactive. We didn't actually explain what they were. And so today we think about transparency and we think about this, and it's more than just the FOIA piece. It's more than just sort of putting out the actual documents. We think about it, and I like to think that there are 3 audiences. There are the skimmers, the swimmers, and the deep divers. The deep divers, these are the folks that actually maybe some of you are and have been interested, and you're digging deep into the specific documents and you want to understand what does footnote 5 actually say and how is that being implemented. And that's great. And I engage with a lot of those folks a lot of the time, and I am smarter and better for doing that. But there are groups of people, swimmers, those are folks who are interested in understanding more generally, but they don't necessarily want to go to the source document. And then you have our skimmers. These are folks who are interested, they sort of want to know, they want to know whether or not we're sort of headed in the right direction. And we need to make sure that we're providing information at all of those levels and constantly doing that. I think with that, I'll pause and I'm happy to go back and forth with questions or otherwise.
Thank you so much, Becky.
So I was thinking, why don't we open it up to our students to see if anyone has any questions for Alan or Becky, or Alan and Becky? We have a question over here, so.
So this question's for Alan. I was curious what changes, so when someone contacts you, what brings it from you just giving advice to the FOIA council actually like publishing an opinion?
Okay, I'm gonna give you a real answer is if you ask me to publish an opinion, I will. It's just gonna take a lot longer. Currently, just because of the way things have fallen out with General Assembly and the way we've been staffed with 1.5 people for the last 21 years, and we're probably going to 2 this year, so we're gonna get a full-time second person. I'm the pretty much only person who's doing this day to day because my other person I work with also staffs General Laws Committee, and so she's been really busy with that, and it's made it very difficult to get the published opinions done with all the other things we're doing, especially during session. So published opinion, I mean, you just ask for one, we'll do one. It's not any different as far as, they're all advisory. They're not legally binding opinions. So I tell people regularly, we try to get it right. We do the best we can, but you're free to disregard. If you disagree with me, you can disagree with me. I'm not going to take it personally or be offended or anything. So the email opinion I send or an opinion over the phone is just as, legally valuable. It's just not necessarily researched as much. It doesn't go through the whole editing process and all that. I can give you an opinion off the top of my head. It's advisory, just like one that I spend weeks or months researching and writing, editing.
And Becky, do you give advisory opinions?
We give advisory opinions to the agency as it relates to particular, we are an advisor to the director of NSA and our senior leadership team. So I'm involved in any number of discussions and decisions. Depending on the particular activity, we try to do our best to document what the rationale was so that our future selves remember why we said this was a good idea, because we frequently have an extensive amount of oversight. So folks from outside of NSA will come in and say, gee, why did you do X, Y, or Z? And we have a document that says, we thought about, here were the civil liberties and privacy risks. Here were our thoughts on transparency. Here's how we moved forward. And then, yes, we're advisory, but those advisories are taken seriously in terms of that space. We have to weigh that, and the director often has difficult questions of which way do I go and how do I do that? And he's made up, he has a number of folks who are advising him.
Thanks. Oh, got one over here.
This question is for both of you. So it seems like a lot of the things we've been talking about could be sort of hot button issues, things like privacy, freedom of information. With both of you having had such long careers in this space, like how do politics, changes in administrations, how do those impact like your day-to-day work?
Alan, you want to start?
Sure. They don't very much for me. Since I'm part of legislative services, we are politically neutral and always, we have to be professionally because we work for both parties, and if there's, independents, which sometimes there are, we work for the independents too. So, politically, we don't take sides, and we do make a point to point that out to people. Also, my role is kind of unique in government in that I give opinions to the public, to the media, and to government officials. I am a legislative attorney, so when I'm dealing with members of the legislature, it's a little different because we're more in the attorney-client privilege zone. But otherwise, I talk to everybody, and I regularly tell people, hey, if the other person on the other side of this calls me in 5 minutes, I'm going to tell them exactly what I just told you. It's going to be the same. That said, the law itself changes pretty much every year. General Assembly amends FOIA every year. I can't think of any year that they haven't, since it was enacted in '68. I mean, we've done legislative history research, and I think it's been amended every single year. one way or another. So as administrations change, as the General Assembly changes, sometimes people favor particular issues or, particular things. They say, oh, we need to respond to this. I'll give you a real example right now. For the majority of the time, we had an exemption that said criminal investigative files may be withheld in the discretion of the custodian. There was no trigger that said you now must release this after a certain amount of time, after the whole thing is adjudicated, after it's a closed investigation or anything like that. There were bills, I want to say 2010, 2011, 2012, and 2016 that would have changed that. We would have opened those, but none of those bills passed. We did studies of the issue. We made some minor amendments, but the general rule was still criminal investigative files could be withheld. They didn't have to be released. Last year that changed. As I think everyone knows, 2 years ago, there was a political change for pretty much all offices and the General Assembly, the statewide offices, and so they pushed through a lot of things they wanted, one of which was to open up criminal investigative files once a case was no longer ongoing. There was a reaction to that this year, and a bill has passed the General Assembly. It's going to go to the governor, which would change it not completely back. It's not a straight repeal, but it basically returns it to discretion, but it then makes provisions so victims and their immediate family, if the victim's deceased, can get it, plus attorneys in post-conviction proceedings. So it's a little more complicated action, a little more, refined. We're going to give access specifically to these people. We're going to take it back to discretion for others. So that's the kind of thing we'll see, as changes over time. But as far as it affecting me, it really doesn't.
Thanks. And Becky.
Yeah, so intelligence really prides itself on being apolitical. We're here to give you the facts and just the facts and not provide any type, we're providing that then to policymakers to make their own decisions. I would say that both protecting privacy as well as transparency tends to almost always be a cross the board in terms of your politics don't matter. You're either very interested in more privacy, or you tend to be comfortable in terms of having more authorities given to national security, but it's not a Democratic or Republican. It tends to be more sort of apolitical in that space. So I really haven't seen those types of differences in that space. Whether when I was at Homeland Security, which was is a more political entity, or here at NSA, those just don't come into the conversation. So it's always an interesting place. You can see in Congress where you have some very interesting coalitions thinking about privacy, and this has been pretty consistent over the years. So we just don't really end up dealing with it from that perspective, and are really looking to instead give our policymakers the information they need to make their own decisions.
Thank you so much. Oh,
don't have to run anywhere. So this is a question for Becky. I was wondering, you talked a lot about the different successes you've seen over the years and areas where you're still trying to improve in sharing information. And as much as you can say, what are you trying to work on improving currently?
So I think this is an area where there is a natural tendency for everybody to not share information with the public, because there are incentives to if I disclose classified information, the repercussions of disclosing that classified information are much higher than if I choose to withhold that information in the immediacy. And so but then in a long-term space, that actually doesn't help you. And so you're sort of dealing with the difference between a tactical decision, do I make this information public, or it's, how much is it going to impact national security, versus this sort of longer-term view that if we do not have the support of the public, the support of the governed, then NSA can't do its actual job. And so there's sort of this sort of immediate of like, oh, I'm going to get in trouble if I release this classified information improperly, without sort of understanding. And so I think what it requires is a constant conversation, a constant looking at it to say, can we do better? How do we do better? What additional information can we do in that space? And so it's sort of, it's not something that's a one and done. I think the places that I really want to make, that I've been trying to focus on, is thinking about how do we continue to talk about the importance of intelligence? How do we train people? How do we talk about it from middle school on up? What are the roles of the intelligence agencies? You know, one of the things we find in education is that you don't have a class on intelligence. You don't have a class on these, 18 federal agencies who are doing intelligence and talking about the importance of them. Mostly what we see is people have education through spy movies where you think of, Jason Bourne or James Bond. And, it's not usually that exciting. And, we're not saving the world and sort of doing these things. And in fact, the place that I often find is the work that we do, ensuring that we have the right civil liberties and privacy protections in place at every point in the intelligence cycle, tends to put lots of people to sleep. And so how do we make that interesting? How do we ensure that the future, all of you understand what the importance is of having intelligence agencies and how they are helping to protect both your national security and your civil liberties and privacy?
Thank you. Oh, yeah, Alan.
That just made me think of one thing that's important to note about Virginia FOIA. Almost all of our exemptions have prefatory language. It says the following records are exempt from mandatory disclosure, but may be disclosed in the discretion of the custodian unless otherwise prohibited by law. In FOIA itself, there are a few prohibitions. There are very, very few of those 150 exemptions. So if I say exemption, what I mean is this is something you don't have to give out, but you can. Some of the things that are exempt but not prohibited are always surprising to people, like personnel records, scholastic records, things like, and this is, I'll just use it as an example, scholastic records. This can get very complicated as well because usually prohibitions are found outside of FOIA. I don't know if you all would remember, back in 2017, there was a political action group that went and asked all the universities in Virginia for their student directories. They then started sending political messages to students on their cell phones. When they did that, there was a backlash, and the General Assembly passed a prohibition on the release of student email address, phone number, and address, so your basic contact information. The way it worked before that is we just had this discretionary exemption for scholastic records. Now, in federal law and other titles of FOIA, they say you shall not release student records except for, and then they talk about directory information. And the directory information is the stuff you're going to see in your yearbook, the stuff like announcements of awards and honors, who was the top of the class, the valedictorian, that kind of thing, but also usually your contact information. But the interesting thing from talking to federal DOE, Department of Education, they let each school decide what they're going to include in their directory and what's going to be open and what's not. And the rule was they had to let you all know what it is. How many of you read your student handbook in college? Show of hands. We got one, two, couple. Did you see something in there that said, if you do not want your information released, you need to notify us and then we won't release it? Well, that was in compliance with the federal provisions about student records. Our General Assembly made a more restrictive rule now that says for that contact information, it is prohibited from release unless you affirmatively in writing tell people, no, it's okay to release. So now we kind of have this three-layered setup for scholastic records. It's discretionary at the FOIA level, except for contact information where you have to get written permission. But in between there are laws outside of FOIA, both at state and federal level, that say you don't release it unless you notify the person and then you have an opt-out. So this is kind of thing like when you're talking about discretionary release and you're talking about what should we release, and Becky was talking about who needs to know this. It's a difference with what I do because I'm not in national security. We don't have necessarily classified information we're dealing with most of the time. For us, it's a right to know law. It's not a need to know. We don't ask why you want something. But I always tell people, if you're asking for something that is exempt, sometimes it is helpful to tell the person why you want it because that might sway their discretion and they might release it when they don't have to. That's all.
Thank you. That actually, when you're thinking, Becky, when you're thinking about the kind of the need to know aspect, is there a process that you go through to kind of weed out what should be national security secrets, and what can the, what should the public know? Is there something that you think about?
So for us, we have the federal FOIA, which is a little bit different than the state one. NSA, unlike other agencies, has a specific law that allows us to keep more information out of the public view than others, and we have to use that with some level of discretion, but we have that. The things we think about is really how are we protecting our sources and methods? So that's what is most core. And I think one of the things that we saw and we've really made movements on over the last few years, there's much work to still be done, is what that meant was NSA could talk about, for example, the civil liberties and privacy protections we have in place, and at a general level, the types of work that we are doing, but not get into the specifics of exactly how you're doing something. And so that was still a shift in terms of how we thought about those things. And today we really think about, would you be surprised if we were doing these things? And is the surprise because of, sort of the sources and methods, or is the surprise because the law is not as clear as what it is we're doing? And we see this example sort of as part of the Snowden leaks, and it's maybe helpful to give a little bit of an example. Section 215 of the Patriot Act was passed in 2001, and the argument was about librarians and librarians having to give up their records to the FBI about what books you had been taking out. And the language was fairly permissive, saying it was anything that was relevant to an ongoing investigation in Section 215. I may not have the exact words right, but roughly get the sense. Their NSA, with the approval of the executive branch, the Foreign Intelligence Surveillance Court, and knowledge of Congress, interpreted that to say we needed all of the metadata records for telephones inside the United States because we were trying to solve an intelligence gap that had happened on 9/11, where we could see calls outside the United States, but we couldn't see calls inside the United States because of the US person privacy protections. When those were disclosed, people were upset because they said that is not a fair reading of the law. That is sort of your secret interpretation, and you should not have done that, NSA. And so what you see unfold then is a new law that gets passed by Congress in 2015 called USA Freedom Act that is extraordinarily specific about how NSA can fill this particular intelligence gap. And I think those are the sorts of things that we've learned, and we continue to constantly ensure that we are, that how we're implementing the laws that are passed by Congress are consistent with how you would expect them to be, as opposed to the specifics of the really cool gadget that can do X, Y, or Z to actually get it done. And so I distinguish those as ways, and really thinking about, are we following, we're following the laws. We were in 215, but that transparency piece wasn't there. And I think I certainly have heard former DNI, Director of National Intelligence Clapper, say that if they had been upfront back in 2001 and explained what it was they needed, that he feels like we would have been in a better place, and that was sort of a poor choice in the transparency space. And I like to say we hold that as a lesson learned and try to continue to improve ourselves and ensure that we're not putting the agency, because that then really impacts our ability to do our operations.
Thanks. Who's next? Who's got a question?
I've got a comment.
Oh, please do.
Just since you mentioned libraries, when Becky asked that, we have an exemption for library information, but it's specific to who took out what. If you want to know who's got a library card, that would be open. If you want to know what books have been checked out, that would be open. If you want to know who checked out which books, that's not open. They've also they expanded that a couple of years ago to include internet activity on the public computers too.
That's interesting.
So actually, I'll just add.
Please go ahead.
This is a great discussion in terms of just thinking about privacy versus transparency, and sort of how do we make these distinctions in these places. And so there's a certain level of I can give broad level information, but maybe we don't want to give the specifics of what books I took out is a great example of just sort of how you can parse a request and think about, I still need to protect the privacy, but I want to give some level of transparency still into what's going on in the system. And so really, those are some of the things we also think about sort of more generally when we think about our FOIA cases here at the agency.
Students? I've got one here. You guys ever seen that show, Let's Make a Deal? You gotta run around with the microphone.
Good evening. The way that Edward Snowden went about his disclosures, what was improper about that, and how should he have went about doing it correctly?
Well, he didn't have authority to disclose any of that information or to download any of the information he disclosed to that. So, you know, we all sign all sorts of different types of NDAs and other things. If he had concerns, he should have been reaching out to the Inspector General, the Office of General Counsel, and expressing what his concerns were in that space. And we have those processes today. We also have an extensive amount of training to make sure whistleblowers have a place to come forward. And then my office, which became a statutory office in 2018, also provides whistleblower protections in those places. So there are a number of different avenues, and we've seen folks use those avenues, beforehand and subsequent, and we continue to try and really engage with folks and have those conversations. I think the other piece here is one of the things that we at NSA think about is not just transparency to the public, but transparency to our own employees. Are our own employees understanding what it is we're doing and how we're doing it? And how do we engage in that space to ensure that they feel confident and comfortable in the work that we're doing here at the agency? And that has meant, you know, continuing to focus on, here are the civil liberties and privacy protections we have in place. This is how we've set our system up. This is what the mission is of the agency. And so that we have a little bit more flexibility because we're in a classified space. But we do spend a lot of time in that arena as well, so that we can ensure folks have a sense that they understand what the work is being done.
Great, thanks. Anyone else have a question? We got one here.
Hi, so on Monday we listened to a talk about FOIA laws and UFO disclosures. I'm wondering, what is your opinion on transparency for UFOs?
So a little background on that question. So we had a speaker on Monday named John Greenwald, and he is kind of a FOIA master guru, and he's submitted over 10,000 FOIA requests to basically every agency in the federal government, and including the National Security Agency. So I don't know if you could comment on UFOs.
Well, you know, it wouldn't be a good question. It wouldn't be a fun class if we didn't have a question about UFOs, aliens, or other sorts of activities. The National Security Agency focuses on foreign intelligence, not extraterrestrial intelligence. So I think we'll stick with our foreign intelligence mission. Thank you.
I don't think we have any exemptions for that. I will, and this is a little bit of a joke, but not exactly. Just as a demonstration of how weird FOIA can get, but how real it can get, I had a headline from a British newspaper that I printed out and I stuck it on my wall because it was British FOIA, which interestingly enough, they didn't have FOIA until 1998, so go figure on that one. But they had this headline, I forget, the Sun, the Mirror, you know, it was one of the British tabloids, I think. Town of whatever admits they have no zombie response plan in answering FOIA requests. So yeah, I would note a couple interesting parallels here with federal law and some of the things Becky's been saying. Like for us, we don't have national security. Of course, we have law enforcement, we have criminal records, and they have exemptions for things like investigative techniques and procedures. One of the few actual prohibitions in FOIA is for the identity of people who have been promised anonymity in exchange for providing information about a crime. So calling Crime Stoppers or a confidential informant that a cop uses, you can't release their identity. So we have some similar protections, but of course it's the state and local law enforcement level, not national security level. I would also notice if you ever look up the State Fusion Center, this is where they do a lot of anti-terrorist stuff. I think it's more domestic rather than foreign intelligence, but they can combine stuff. They're exempt from FOIA. Period. They don't have to release anything. They're part of the state police, and they work with other state fusion centers and the federal government and others. They don't have to release anything. They're pretty much just out completely.
Great, thanks.
Can I follow up on
please.
that? So those fusions, I'll just say that the fusion centers are an interesting place because they are a sort of state and federal and local entities. And so particularly back when we were just starting up DHS. So I started DHS about a year after it started in 2004. And we had a lot of conversations about, how do the state FOIA laws and the federal FOIA laws apply? And there was a lot of thought put into sort of whose records are where, because the states all, Virginia has one set, and if you go to Michigan or Indiana, some of those are very different. And so there's sort of different levels of presumption in terms of what information was going to go out. And so there was a lot of conversation about, can you share this information with the Virginia State Police, and will it then subsequently be, FOIA-able, so to speak, and so you've lost the protection. So I just, how these interact and all the laws are really an interesting space in terms of it rarely, the interesting ones tend to be extraordinarily complex because you want to make sure that you're both giving out the information you should be, but protecting the information that shouldn't be going out. So those fusion centers were particularly, and undoubtedly still are, some of the more interesting FOIA case laws.
Any more questions from our audience?
Is anybody from Florida?
Florida.
You ever use FOIA in Florida?
Do you ever use it?
Yeah.
Rarely.
Okay. I'll just note every once in a while I talk to a reporter who's coming out of Florida, and Florida is an interesting one because they put FOIA into their state constitution. Here it's statutory law; it's not in the Constitution, and theirs is really open. I think they're about the most open, especially with criminal records. Whereas we are one of the most closed here in Virginia. So I get reporters who come from Florida and have been working with, the police beat section of the paper down there, and then they come here and they go, "What the hell, man? I can't get anything. What's going on?" So as Becky was saying, every state has its own version of FOIA, and they could be, it's all the same concept, but the actual application can be radically different.
I actually have a question. Do you, and this is for Becky or for Alan, do you have ever experienced tension within your office about what you want to release or what you want to share or what your mission is? I could imagine there might be some.
Absolutely, and that's the best part. We intentionally built our office within NSA to ensure people felt like they could ask really hard questions because we get hard questions. I get hard questions that I don't get to control from the outside world. So we really designed our office to ensure we had very diverse perspectives on any other topic, because I think when you have that diversity of discussion, you come up with better answers. And we really have been embraced that from the very beginning. When I first started at NSA, I'm a privacy person by training. I've been doing privacy since the late 90s, and so I come at it from that particular perspective. I brought in folks who were longtime NSA folks who do signals intelligence, who were very uncomfortable that there was a sign outside that you could now get off at exit, at the National Security Agency. And those are some of the best conversations because everybody's bringing to bear their different perspectives. And when we then go out to our overseers and the public and others, we're better prepared because we can understand what are some of those questions we're going to get. It's the same reason that our office early in my tenure, we decided to bring in a bunch of the civil liberties and privacy groups into NSA, and half of NSA thought Becky was crazy, and the other half thought I was really, really crazy. My deputy director and my director at the time thought it was a good idea, so we went forward. But hearing voices directly with different perspectives is so important. It makes you better at your job. And so absolutely, it's some of the most fun you can have on any given day. And you want to be able to make everybody's argument, and then that can help conform what's the right decision based on that information. But if you only have yes people, you're not going to necessarily get to the right place.
Alan?
I 100% agree with what Becky just said, but I have a slightly different perspective on it because basically we're a 1.5 person office. We don't get that many requests that are actually for us. We get a lot of requests misdirected to us that I have to then say, you need to go ask the other locality or state agency, whatever it might be. But I mean, the nature of my job is such that I am constantly dealing with people who disagree with each other. It's usually, citizen versus government, or sometimes government versus government. Sometimes we get stuff like an elected official who disagrees with the other elected officials on their board or council. And they say, hey, don't they have to do this? Don't we have to do this? We've seen, and if you look in the news, I think it's Suffolk School Board has repeatedly been sued by one of the school board members for FOIA violations, and she's won a couple times now. We don't see that often, but I mean, that stuff does happen where people just disagree. One of my favorite examples came from backyard chicken coops. Anybody keep chickens? You do, okay. So, you like your fresh eggs? Okay. Do your neighbors not like the chicken coop? Did they ever raise an issue? Okay. So, in one of the counties, there is a big issue about people keeping chickens in their backyards. And one side says, I like my fresh eggs. The other said, yeah, but that's, spreads all these diseases from the chicken coop. They're not clean animals, all this. We don't want them in our neighborhood. So there was a lot of fighting back and forth. Their county board of supervisors had a closed meeting. They went into the closed meeting to review the performance of the county administrator, which is an allowed exemption. And they go in there and they said, okay, so what are you doing about this chicken problem as part of his performance review? Well, they came out and a couple different members spoke to the press. One of them said, well, we talked about the policy on chickens and keeping coops in your backyard because it was necessary to understand the policy in order to understand what he was doing about it and actually give a qualitative performance review. Another member came out and said, no, we strayed off topic. We were no longer talking about his performance. We were just talking about the policy itself, and that was not a proper topic for closed meeting. We should have come back out and done that in the public. So two members in the same meeting talking about the same stuff had a disagreement as to what they talked about. I mean, so you can see tensions like that all the time in FOIA. This is one thing where if you ever call me and you have, they kept this from me, they did a closed meeting, they kept a record from me, I'm almost always going to have to tell you, well, if, then. I won't be able to say yes or no, because if you don't have the record, I don't have the record either. I can't tell you whether it's exempt or not if I can't see it. And that's something just to note. FOIA challenges go through the court process. On the record side, usually a court will actually take the records under seal and they can review them and then say either they should release them or shouldn't. They did it right, they did it wrong. On the meeting side, one of the best resolutions for a closed meeting issue I've seen came out of Richmond Circuit Court. They took sealed depositions and they concluded, based on the testimony and deposition from all the people who were in the closed meeting, it should have been open. It should have had minutes, but because it didn't, they unsealed all the depositions and said that way the public can see what's going on. Yeah, so I mean, the tensions they're constant. Yeah.
That's great. We are hitting the end of our time, unfortunately. Thank you to both of you so much for being here. Can we give them a round of applause? Thank you, students, for coming. If you didn't get a ticket, please come up and grab one from me or turn in the tickets that I've already given you. And Becky, thank you so much. I really appreciate it.
Absolutely. Happy to do it. And it was great questions, including the UFO. It would have been fun if I didn't have a UFO or have discussions with chicken coop.
Oh, yeah. Well, I'm really glad you were able to come. So thank you again, and we'll be in touch.
Okay, great, thanks, bye-bye.